Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in.
Good morning and welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Normally, each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. As you can tell, this is not our normal background. Today we are broadcasting from ILTACON 2022 in National Harbor, Maryland. I have with me two guests for this session, Dunne and Ian Chivers from, how do I pronounce it properly?
Delium.
Make sure I get that correctly. Monica has worked in legal technology and digital evidence since the mid-1990s, with over 25 years of experience consulting in eDiscovery and hearings. I could go on for a long time, but I'm going to give just brief introductions. Ian has worked in legal technology and digital evidence a little bit longer, since the late 1970s, and has led Delium, focusing on evidence presentation technology for more than 25 years. And presentation technology is really what we're here to talk about today. But I want to work us into that a little bit. So 1970s, it's a while back. Ian, you are credited with the first paperless hearing globally, which I understand ran for more than 100 days in 1994. Tell us about that.
Well, yeah, there was a fairly serious gap between the late 70s and the early 90s, obviously. But yes, we did run a more than 100 days of hearing in 1994 without paper in the hearing process. It worked. At the end of the day, the judge wrote a paper and said, well, in his view, it had reduced the duration of that hearing by at least a third.
So that's way beyond leading edge, far out into bleeding edge. How did you get from paper to paperless in that?
I was contemplating you asking me that question. And I think it might have been youth and folly more than anything else.
But it worked.
I was too young to know that it was likely to be a problem.
Uh-huh.
I had a very supportive senior counsel, barrister in our terms, and judge. And dare I say, Friday night drinks, we just talked about what we were doing. It was early days of actually being able to afford imaging technology. I'd been playing in that area. They sort of said, well, why can't we take this into the room? We went through and ticked off the reasons why we couldn't, and so we just did it. But yeah, it's a long time ago.
So what did it look like in those days? Because I'm sure you were not using any of today's technologies at that time.
Well, without wanting to sound bitter and twisted about it, in any number of ways, we were using similar technologies to the ones that are being used now. Essentially, it was one PC with a lot of cables going out from it to a series of screens. And once something was put on that screen, everybody saw it.
We here in the U.S. have a challenge with using these types of things in the courtroom because our attorneys are so indoctrinated in the use of what we call Bates numbers. And they want to see every page and the number on every page. You must have had something like that to deal with then, too.
Oh, we certainly do. I think that's probably a better question for Monica than for me.
Okay.
I wasn't there in 19.
I know you came a little bit late.
I was working in an inquiry environment where we didn't have the obligations of numbering, and a few years later, as we got more into commercial space, the Australian numbering process became fairly standardised, and that Monica was seriously involved in making that happen.
Well, why don't we turn to you, Monica?
Okay.
How did you get into all of this?
I got a job in a law firm as a temp initially, on the back of having 18 months of backpacking around Australia, which is something that a lot of Aussies do. They chuck in their jobs and go travelling. So I really fell into it. But the department I was in was one of the first litigation support departments in Australia. And the lady that was running it was looking at technology and ways that we could make the process simpler, and the firm really backed it. We were a separate practice group and profit centre, so we weren't just an adjunct to the IT department or the photocopying department. They really treated us as a group that could innovate, and so I fell into that. But in the early days of those Bates numbering machines where you stamped every page, and my back is still suffering from that.
And either it turned or it did not turn.
Yeah, that's right. And how annoying was it when it didn't?
Right.
But then we moved on to sticking labels, printing the numbers and sticking labels on the pages. And then, the numbering systems just evolved from there to being now watermarked.
Now, you in Australia have a numbering system that we Americans either don't know about or sometimes have a very hard time getting our heads around.
Yeah.
Explain it to me.
So it's a 4-level numbering system consisting of 3-digit alpha prefix, which usually identifies the source that the document has come from. So party A, B, C, and party D, E, F. And then you have either it stems back to the paper days, a box or a folder level. And once again, that can either be just an arbitrary number that you apply, or it can designate where the document has come from. And then there is a 4-digit page number that gets applied. So it takes a little while to understand, but what it means is, and one of the great benefits of it is that in Australia, a document has a unique identity for the duration of its existence in a litigation. So documents don't get renumbered when they're applied in witness statements. They don't get renumbered when we go to court and talk about the document. So once you know a document's identity, you can refer to it that way all the way through the litigation. And for me, that makes a really big difference.
So the first thing that happens is unique identification, and that does stick with the document.
Right.
Yeah.
We have people who are concerned that if there's a gap, that's going to signal something.
Yes, we got over that concern a long time ago, but it was, back in the 90s. Yes, it was like, where's that missing page? Because there's a gap in the numbering. These days, people don't even think about that.
Now, there are a couple of things that you, in our preparation for this, mentioned. Personalization and interactivity. What are you talking about with that?
Do you want to?
I think that goes right back to the very beginning of these electronic courtrooms. There was no doubt that by putting evidence in front of people,
Quickly.
the same evidence in front of people quickly, that the witness, the judge, and the parties all saw the same thing, and they saw it essentially immediately. There was no doubt that produced a very significant improvement in the hearing process. But it was also fairly obvious quite early on that while that the courtroom is an intrinsically personal event and it's an intrinsically interactive event. So what would happen is that the document, the evidence would be put onto the screen, and that was fine. Everybody was seeing it. But then what you'd see was everybody in the room finding their paper or electronic equivalent to that so they could have the marked up annotated version. Counsel wanted to have the questions that they were going to ask the witness endorsed on the paper. So they could be looking at the paper and they'd have the question there. In the months preceding the trial, people would be highlighting and they'd want to see that highlighting. So that's the personalization. I think what we've been trying to do and what we do with Elium. Sorry.
I'm just
Get
trying
to
to get
that.
my head
Yeah.
around the idea that you have the questions right on the document.
Well, on
Your
your
personal
copy of the
okay.
document, and
Not
that's
what everybody's seeing.
I wouldn't think so.
everybody
Good.
is seeing the one thing, and that
Uh-huh.
that, for want of a better expression, is the bald version of the evidence.
Right.
But
To work properly.
most people in the room are then looking at their private version.
Ah,
And
okay.
so what we're trying to do, what we do technologically, is reproduce that. So that instead of showing people the document, what we do is that we, in effect, hand the document to them, and the document we hand to them is their own. It's not the standard version. So the witness sees the blank, unmarked up version.
Mm-hmm.
The judge initially sees the blank version, but the judge is then free to mark it up his or herself. And the parties are receiving the copy of the document, the edition of the document, which has got all of that pre-trial working effort associated with it, and also has. And then you get to the interactivity part. The interactivity part is that we can then work with the document and manage it on an ongoing basis. If the witness, if the question is, if it's a criminal event, you want the witness to identify where the gun was found,
Right.
you can say to the witness, well, put an X on the photograph at the point, and the witness, in fact, can then distribute that view of the evidence in a way that everybody can see what's come into the process there. So for us, and I want to sort of hand this over to Monica, but for us, the important thing is that we believe there's an inevitability about the technology, in a sense, moving back to the procedure that existed before, which is where the technology supports that interactivity and that personalization, which is a crucial part of the hearing process.
With all of that in mind, then, so I can get a better understanding
Yeah.
what you all are doing today, walk me through the process. When do you first get involved in a matter?
So another element of our business is managing eDiscovery. So quite often we're involved right at the very beginning.
At the onset, okay.
Yeah, at the onset. But often we get contacted by firms that have got a trial coming up, and sometimes that is 6 months out, sometimes that is 6 days out, and you just have to deal with the calls as they come in. And with the onset of the pandemic, obviously we were doing a lot more remote and hybrid trials. And really the benefit of Delium is that it's just a website, so there is no need for specialist infrastructure. It's being designed so that the parties can do a lot of what would traditionally be done by a court operator themselves. And so that means that for us to deploy a Delium e-trial, we really don't need very much time. As long as we've got the data that we can import in, we can set up a trial that is anywhere. We ran trials from Brisbane that were happening in Copenhagen and Edinburgh and Greece, all at the same time.
So they contact you.
Yeah.
You have a discussion, presumably, about what they need to accomplish or want to accomplish and how.
Yes.
You get some data and bring it into the platform. What does that look like from the user's perspective once they get to the platform?
It looks a lot like it would look like in their eDiscovery software. So there's metadata about the document, there's the image, and then there's the capacity for them to analyze it and put comments and annotations and other markup that will be useful for them when they're in trial.
And so they'll do that type of work in preparation for the
Yes.
trial.
Yeah.
When they get into the courtroom,
Yes.
what do they see and what do they use?
Same platform. So normally the way it's structured is each party will have an individual private database, and then there'll be a hearing database in the middle, which based on security and permissions has the capacity to talk back to their individual private databases. So when a document's brought up on screen, Delium looks back to their private database and overlays all of their analysis on the document. So they don't have to run separate searches. It just appears. They don't have to run a search at all.
It's right there.
It's right
for
there
them to use.
immediately. Yeah.
And when you bring the files up for them to use during the trial or hearing or whatever it might be, what form are those files in? Are they PDF, TIFF, native, a combination?
A combination. A lot of the time it's PDF, but the Delium viewer supports 300 native files. So there are lots of different formats. Evidence comes in all sorts of formats,
Right.
and so we've got to be able to support whatever format the native evidence was in.
How frequently do attorneys, or which is the proper phrase in Australia? Attorneys or lawyers? Or do you not say?
Lawyers. We
Okay,
don't care.
lawyers.
We service a global market.
Right.
So
So how often do lawyers use the native files during a trial as opposed to PDF or something like that?
it really depends on the nature of the litigation, the subject matter. So most of the time PDFs are sufficient, but if you're dealing with complex financial transactions where Excel spreadsheets, the issue with the spreadsheet might be the calculation sitting behind a cell, then you need the capacity to drill down and see that information.
I think it's fair to say that the preference now is for the native file, even at hearing.
Okay.
But there are lots of native files that are difficult to comprehend I'm talking in a logical sense, not in a technological sense.
Right.
The Excel spreadsheet is the classic example. You're not necessarily wanting to see what's on the spreadsheet and what would render to a virtually printed PDF. As Monica said, what we try to do is to analyze the calculation base.
Right.
And so you're needing to address that.
Right, because there are situations where you want whoever your audience is to see the formulas.
Yes.
You
Absolutely.
want to see how a pivot table is structured, because
That's
that
right.
can be critical to
That's
the
right.
outcome of the case.
Yes.
And you support, as you said, 200 some,
300.
300 some file formats. What do you see as the biggest challenges folks face as they are trying to make use of your platform? And I'm not saying challenges so much with the platform itself, but
No, I
probably
think
more
it's-
the concept of using it.
I think it's the perception that they need somebody independent to do the driving for them. Obviously, they're in a pressurized situation when you're cross-examining a witness. There's a lot going on in your mind. And so the concept of taking on the responsibility for being the person that brings the evidence up on screen for the uninitiated seems like just a step too far.
We call that the hot seat.
The hot seat, it is.
Yes.
It's a highly pressurized role. But the benefit of Delium is that counsel can prepare their cross-examination notes and have them uploaded into Delium. And really it is, as they're reading sort of the questions, it's just clicking on a button. And it doesn't have to be them. It can be one of their team members. But it's somebody in the hot seat who understands the evidence, understands the questioning, the line of questioning, rather than it being somebody who's just reacting to a number being called out.
Right.
And the other thing is that you just don't have a situation where a number's called out and the document's not already in Delium. Whereas if you've got somebody preparing outside of the evidence presentation system, you sometimes have that situation where there's crickets. There's
We have to run.
we don't have that
Right.
document. So
Right.
that's another benefit. But we've just introduced this new feature called Counsel's Notes, where our clients are telling us that they are literally uploading the latest version as counsel are standing up to speak almost.
I was going to ask about that because I've had the situation, and I'm sure it's not unique, where we're in trial and at 3 a.m, we get the document from the other side that we never knew about before, and we know the judge is going to let them use, even though that's not supposed to happen. So we have to scramble to figure out what to do.
The classic situation there is that as counsel, as questioning counsel, you'll get an answer from a witness which you don't expect. And in the paper world, what you do is turn around, you talk to the person who's supporting you, and you send them off to find the document. Well,
Right.
Delium replicates that process. So effectively, I can ask the person behind me, and the person might be behind me in London while I'm working in Brisbane or Melbourne or wherever. They can find the document, they can deliver the document, hand the document to me and me only.
Well, push the document onto your screen.
Right.
I think
Yes.
we're mixing our metaphors
in a virtual
here.
sense. Push the document to me. I then say, yeah, well, that's the document I want, or it isn't. It may be that it's questionable whether that document can be shown to the witness. So I would then, or they would then, push it on selectively to the judge and opposing counsel. We can then have, I don't know what the expression here is, we would have a voir dire argument in our terms to determine its admissibility. And then, and dare I say, this has happened on more than one occasion, the judge, in fact, having made the determination that the evidence is appropriate for presentation to the room at large, presses the button which says, show that to everybody.
Right. Yeah. Well, sometimes it's a sidebar, sometimes it's something
and
else.
this,
But
you
same
know,
idea.
in the traditional in-person courtroom, that would be all managed by switching technology and turning people's screens off. DLAM's
None
just
of
a
that.
website, so we've removed all of that infrastructure control.
In the paper world, somebody's running around making 20 copies of it.
Right.
Yeah.
And I think you bring up an important point. It's been a long time since I've tried a case. But the last time I was trying a case or even testifying at a hearing as an expert witness, the systems being used were ones where you had to figure out ahead of time which documents were going to be in there. And it was usually a fairly small, carefully
Curated set.
set. It sounds as if you don't have to operate with that same limitation.
We do, but you've still got access to your private database. So if you need to find a document,
Things can be
that's
brought
where
in
it will
quickly.
be.
And we
and
didn't
transfer.
have
Yeah.
we didn't have the ability to do that extra part.
Yeah.
It was just what was in that system that day, and if we didn't have it there, well, maybe during a break we could sort it all out.
Yeah,
Maybe.
and the parties, everything is subject to permission. Who can publish a document? Who can see a document? But we can give the parties the ability to do their own imports, so it's not reliant on a support person to do that. If they've got a new document at 7:00 in the morning, they can upload it themselves and notify the other side that it's there.
My notes are vanishing as the Gaylord tries to get me logged in when I don't want to be logged in. We are coming close to just trying to take over my world. So now, is what you're doing, do you see this as a long-term solution for people? Is this like a temporary offering and something better and different is likely to come down the road?
We think this is the next evolutionary step in how hearings will be run. So, with the advent of COVID and the use of platforms such as Teams and Zoom, it was kind of inevitable that people would start to use their share screen functionality. But that's the equivalent of just, everyone seeing the same thing at the same time, which is not how employers need to work.
No, right.
So we've been invested in what we've been developing for a number of years now. We've always believed that we would have to get to this stage where evidence presentation became like online banking. We used to go to the bank, have a teller, use a computer to do transactions for us.
The teller was doing the using.
The teller.
Right.
So
And you were just standing patiently waiting
for something to happen. But online banking has evolved where now when my kids are calling me from Australia saying, "Mum, we need money," I can, on my phone from a chair here, just transfer the money to them. And it's that evolution of, the personalization, the interactivity, the control that being in charge of your own sort of transactions delivers. And we think that's the way hearings have to evolve as well.
So
I think it's fair to say that it needs to be. Well, it would be better to describe it as revolutionary and disruptive. That we can't realise the benefit of the technology inside the courtroom until we can support the individuals who've got to do things inside the room. So it keeps coming back to, first of all, the concept of personalisation. Everybody in the courtroom is different. Everybody has a different job. Everybody needs to see and do different things. And then the doing is the interactive part. Unless there is the capacity to interact, just as Monica said, to immediately move money from place A to place B or move evidence from place A to place B and to evolve that evidence, then that's where the hearing process, we there's no doubt in my mind that at least for the foreseeable future, there'll still be people who'll be determining disputes. But we want to facilitate that process as effectively and fully as possible.
And from any device, anywhere, without the need for specialist trained staff.
Which is a huge change.
Which is a huge change. Yeah.
Yep.
So we want to empower the legal
Mhm.
teams to run their cases the way they used to in, the paper days.
Well, that sounded like a final word, but does either of you have a final word to share with the audience here?
Come and see us at booth 740 and we'll
There
show
we
you
go.
what we're talking about.
Wonderful.
Be very pleased to do so.
As well, Monica, Ian, thank you so much. Monica Dunne is Director Client Technology, and even Chivers.
Chivers.
Yes, got to make sure I get that.
The Scotch, but spelled a little differently.
Director, but my notes are for elaw. What are your roles at
We are
Allium? Same roles?
same roles.
Okay.
Same roles.
Yeah.
Yeah. Two halves of the same sort of company group.
Right. Well, thank you very much for taking
Pleasure.
the time to join us.
Thank you
today.
very, very much for inviting us. It's been very kind of you. Thank you.
Okay. Thank you. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Thank you all.